May it please Your Honour, I'm Teng Jing Han. Together with me is my learned co-counsel, Ms. Ng Ibe. We are acting on behalf of the appellant. If there is no further question, I shall start with my submission for issue 1 and 2.
Please continue with your submission.
Thank you, Your Honour. For the first issue, it is whether the High Court judge had erred in his decision in ruling that IDP2 was not admissible in evidence. Your Honour, Section 67 of Evidence Act 1950 provides that if a document is alleged to be signed or to have been signed wholly or partly by any person, the signature and handwriting of such of the document is as alleged to be in that person's handwriting shall be proved to be in his handwriting. Section 68 said that if a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for the purpose of proving its executions if there is an attesting witness alive and subject to the process of the court and capable of giving evidence. Your Honour, in the case of Sembagavali Murugasan against T. Seng Hock, the court ruled that evidence by an attesting witness must be as prescribed as Section 68 of Evidence Act. And also in the case of Elizabeth Lee Jingjing against Masni or Roslinda Imanja, it was held that if the testator were deceased, that thus the onus is on the plaintiff under Section 69 to prove that such signature on the POA and the memorandum of transfer was signed by the attester by calling a witness who knows his handwriting and signature. We also refer to Section 47 of Evidence Act, which said that when the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to have been written or signed, that is, was not written or signed by that person, is a relevant fact. Your Honour, the appellant in this case has in her mean produced IDP2, which was signed by the respondent in the witness of PW2. PW2 also testified that the respondent indeed had signed the document in front of him at his law firm. In view of Section 68, IDP2 is a document which required to be attested by a witness. The appellant has discharged the burden of proof by having PW2 to prove that the respondent's signature on the documents by virtue of Section 67. Furthermore, the expert witness introduced by the respondent failed to identify whether the signature belonged to the respondent. Such fact is relevant under Section 47. Yes, Your Honour.
So, if the expert witness failed to identify, does that mean the signature does not belong to the respondent? Do you agree with that?
Your Honour, I do not agree with that. The appellant rests this issue is to prove that the respondent had failed to prove the fact that the signature was forged. Thus, based on the testimony made by PW2, the signature shall remain as hers until she can prove otherwise.
Duly noted.
By virtue of Sembagavali Murugasan against T. Seng Hock and Section 68, IDP2 should be admissible as the signature by the respondent is proven by the testimony of PW2. If Your Honour has no further question on the first issue, I shall then proceed with the second issue.
You may proceed with the second issue.
May it please Your Honour. The second issue is whether the High Court judge had erred in his decision when he concluded that testimony of PW3 would not be sufficient to corroborate with PW2's evidence. Your Honour, corroboration is defined by Lord Helsham in Kilburn's case as evidence to confirm another evidence. So corroboration tends to support other evidence to make it more probable. The general rule is that no particular number of not be sufficient to corroborate witness are required to prove any fact before the court. Facts can be established by a single witness. Section 134 of Evidence Act 1950 provides that no particular number of witnesses shall be in any case be required for the proof of any fact. We can see in the Balachandran against PP, it lays down that the testimony of a single witness is sufficient to establish and prove a fact. According to Reid against Tatam and Khao Cheng Bok against Khao Cheng Pun, it is clear that the statement of one witness is sufficient, if believed by court, to establish any fact. It is not necessary for the statement to be corroborated. The statement may also be proved by documentary evidence. The quality of the evidence should be the primary concern instead of the quantity. According to Vadivelu Tiba against State of Madras, evidence has to be weighed and not to be counted. The late Gopal Sri Ram in MGG Pillai against Tan Sri Dato' Vincent Tan Chi Yon states that the authorities provide that there was no necessity for the respondent to call other witnesses to prove his general damages. Furthermore, in Ram August Tewari against Bideshwari Tewari, the court has observed that the evidence of every witness is to be judged on its own merits, and if there is nothing in his evidence or in the evidence or other witnesses as mean in a case to discredit him, it cannot be disbelieved on the ground that there is only one witness on the point and no other witness has been examined to support him. Your Honour, in our case, PW2 had clearly testified that the respondent had signed IDP2 in front of him at his law firm, Tetuan Arkelingam & Co. on the 1st October 2019, and that he had witnessed her signature on the said document. The judge had erred in his decision that testimony of PW3 would not be sufficient to corroborate PW2's evidence. It stipulated in Reid against Tatam and Kao Cheng Bok against Kao Cheng Poon. That corroboration is not necessary if statement is sufficient to establish certain fact. PW2 has, as advocate and solicitor, his testimony is sufficient to prove that the respondent had herself signed on IDP2. It is only on the court for the court to determine on the weightage of PW3's testimony as illustrated in the Vadivelu case. Your Honour, if there is no further assistance I may provide, my co-counsel shall proceed with the next issue.
Yes, you may proceed.
Your Honour, my name is Ongibei, the co-counsel representing for the appellant. If Your Honour has no preliminary questions, I would like to begin my submission.
Yes, you may begin with the submission.
Much obliged. And appellant's third submission is whether the trial judge erred in his decision when he rules that the WhatsApp message was not admissible in evidence. According to Section 90A, allowed the production of computer-generated document or statement tendered as evidence. Under subsection 2 of the sections, such evidence may be proved by tendering certificate by signing by the person responsible for the operation of the computer. Furthermore, under subsection 4 of the section stated that when the certificate is tendered, it is presumed that the computer is under good working conditions. As we refer to the case Mazlan bin Mat Nepal against PP, paragraph 49 stated that the subsection 2 of section 90A Evidence Act is permissive and it is not mandatory. As per the learned judge Augustine Paul in the Hanafi Mat Hassan against PP, analyzed the section 90A Evidence Act where the document produced by a computer in the course of its ordinary use may be proved by the tendering in evidence of a certificate under section 90A subsection 2 or by way of oral evidence. Where the decision is followed by the case Ahmad Najib bin Aris against PP under paragraph 33, and the learned judge further explained that providing a document was created by computer is ordinary course of use requiring the specific information including the matters presumed under section 90A sub 4. So we'd like to we'd like to draw the court attention on the case Bergamo Development Malaysia Sdn Bhd, Act Development Sdn Bhd and another. Paragraph 8 stated that to tender the authenticity of the evidence, the one who is responsible for the care and management of the usage computer and the extract evidence and print from the computer in the course of their ordinary shall be proved. In our case, the trial judge rules that the WhatsApp message not admissible as there is no sijil perakuan has been tendered and there is no authentication by the oral evidence. However, I would like to draw the court attention to the decision in the case Hanafi Mat Hassan and also Mazlan bin Mat Nepal, which held that the tendering certificate is not mandatory and even the absence of the certificate, it may be tendered by in the oral way. And in our case, the WhatsApp message tendered as evidence is testified by the appellant in oral way, and she shows that the evidence produced under her care and the laptop is under her management before and after the evidence is produced, and which is also satisfies the requirements of oral evidence to tender documentations evidence stated under the case Ahmad Najib Aris Binaris, and furthermore, by applying the case Bergamo Development Malaysia Sdn Bhd, the authenticity of the evidence has been proven by the appellant through the oral way. In short, the trial judge erred in law and the WhatsApp message shall be admissible in evidence. Concluding our submissions, the appellants humbly praise that the appeals to be granted.
Duly noted. Respondents, you may submit your submission now.
Your Honour, if I may.
Yes, you may.
My name is Aswaitan as the lead counsel for the respondent, and together with me, Yaswinia Anak Perempuan Maniam as the co-counsel for the respondent. I will be addressing the first and second ground of the respondent's submission. The first ground is the appellant failed to prove on the balance of probabilities, which resulted in IDP2 to be inadmissible as evidence. The appellant testified that IDP2 was signed by herself and the respondent on 1st October 2019, which was witnessed by PW2. However, the respondent denied having signed IDP2 and asserted that the signature on IDP2 was not hers. On the other hand, PW2 testified that the respondent signed IDP2 in front of him at his law firm. In civil cases, burden of proof is generally determined by the pleadings, which will reflect the issues to be proved. The general rule is that the plaintiff has the legal burden to prove the case on a balance of probabilities, while the defendant assumes the evidential burden to raise sufficient evidence. The case of public prosecutor against Yuvaraj explained the use of civil standard of proof. The evidence ordinance applies to civil and criminal proceedings alike, and there is no explicit distinction between facts required to be proved by the prosecution in criminal proceedings and facts required to be proved by a successful party to civil proceedings. The burden lies upon a party in a civil suit to prove the facts which constitute his cause of action or defense upon a balance of probabilities. If other facts are proved, a particular fact, the existence of which is a necessary factual ingredient of the offence, shall be presumed or deemed to exist unless the contrary is proven. According to Section 101 of the Evidence Act 1950, when a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. Since the appellant testified that the respondent signed IDP2, The burden of proof falls to the appellant to prove this fact. According to Section 71 of the Evidence Act 1950, if an attesting witness denies or does not recollect the execution of document, the execution may be proved by other evidence. The respondent denied having signed IDP2, and the appellant had neglected to adduce any expert evidence to support her allegation on the authenticity of the respondent's signature. Failure to do so means the contrary is not proven. According to Section 73 of the Evidence Act 1950, in order to ascertain whether a signature is that of a person by whom it purports to have been made, the signature may be compared by a witness or by the court with the one which is to be proved. The respondent assumes evidential burden to raise sufficient evidence and has successfully done so with DW1 as an expert witness, where he stated that he was unable to do handwriting comparison since there were no similarities in the handwriting in specimen documents provided to him by the respondent and the signature on IDP2. Concluding the above, the appellant failed to prove on the balance of probabilities regarding the authenticity of the respondent's signature on IDP2, and the High Court judge did not err in his decision when he ruled that IDP2 was not admissible in evidence. Your Honor, if there are no other questions, I would like to proceed with the second round of submission.
You may proceed with the second round of submission.
Thank you, Your Honor. The second round of submission is PW3's testimony would not be sufficient to corroborate PW2's evidence.
Counsel,
Yes, Your Honor.
does that mean that you are agreeing with the appellant?
Yes, Your Honor. We agree that the respondents agree that the High Court judge had erred in his decision.
Okay, noted.
Here, I would like to bring the attention of this Honourable Court to the case of Vadivelu Tevar and State of Madras, where it is stated that evidence has to be weighed and not counted. PW3 testified that she had accompanied the appellant on the day of signing on 1st October 2019, but she was not present during the signing itself as she was waiting at the reception area of law firm. Taking aside the point of interested witness, PW3 did not actually witness the respondent signing IDP2 as she was not present in the room where the signing took place. There is no weightage in PW3's testimony at all, and PW3's testimony is irrelevant and should not be admissible as evidence. Your Honor, if there are no further questions, this concludes my submission as the lead counsel for the respondent. The third round of submission will be addressed by the co-counsel for the respondent.
Co-counsel of the respondent, you may make your submission.
May it please Your Honor, I am Yashmiya Maniam, appearing as respondent co-counsel for the respondent and Ali. I will address the third ground of the respondent submission. If Your Honor has no preliminary questions, I would like to begin my submission.
You may continue with your submission.
The third ground of submission will be whether the High Court judge erred in his decision when he ruled that the WhatsApp messages was not admissible in evidence. We refer to the case of Mo Ichik against Sobo Sundrian Berhad and others, in which the High Court held that the party who adduces the WhatsApp message must meet the procedural requirements of admitting a document produced by a computer. In the often cited case of Gnanasekharan Analalaki Pararajasingham against public prosecutor, the Court of Appeal held as follows. Section 90A of the Evidence Act 1950 makes computerized records made in the course of its ordinary use admissible if the following is proven: that the documents were produced by a computer and the computer records are produced in the course of its ordinary use, and these can be proved either by a certificate signed by someone solely in charge of the computer, which produced the printout as required by Section 90A sub 2, or by calling the maker of the document. In this case, Zainul was able to testify with regard to the documents because he was in charge of the operations of current accounts. That decision was followed by the Federal Court in Ahmad Najib bin Aris against public prosecutor. In the celebrated case of PT against Azila bin Adri and another, it was held that the call logs were produced by computers in the course of their ordinary use by the very makers, namely PW 61, 62 and 63, hence dispensing with the requirements of tendering to the court signed certificates that they were responsible for the management of the operation of the computers or for the conduct of the activities for which those computers were used for. In the present case, the appellant testified that she printed the WhatsApp messages from her husband's computer, which she had borrowed as her own device had crashed. These facts show that the appellant is not in charge of the operations of the computer, as she merely borrowed the device as her own device was not in a working condition, which makes her not capable of testifying with regard to the WhatsApp messages adduced in evidence. Thus, the High Court judge has rightly ruled that the WhatsApp messages would fall within the ambit of Section 90A Evidence Act, and on the facts of the case, the elements for admissibility have not been fulfilled, as no sijil perakuan had been tendered, and there has been no authentication by oral evidence either. Concluding our submission, the respondent humbly pray that the appeal to be dismissed.
Thank you, counsel. So I have considered with my due diligence of all submission brought by the appellant and respondent counsel before me. At this instance, I shall give my ground in allowing the application of the appellant and dismissing the objection by the respondents. On the first ground of the appeal, I am aware that evidence IDPW2 should be admissible. That is because according to section 67 and 68 of the Evidence Act and in reference of the case of Semberoli Murugesan against T. Sanghok, which applies the section 47 by having PW2 to prove the respondent's signature on the document by the virtue of section 67. And for the second ground as of the appeal, I would like to say that the appellant have made the point clear as it is stated in the case of Wright against Tatum and Khao Cheng Bok against Khao Cheng Poon that corroboration is not necessary if the statement is sufficient to establish certain facts. So in the current case, PW2 as advocate and solicitor, his testimony is sufficient to prove that the respondent had herself signed on IDP2. It is only for the court to determine on the weightage of PW3's testimony as illustrated in Vadivellu Thevar against the state of Madras. And for the third ground, by taking in the case of Hanafi Mat Hassan against public prosecutor and Ahmad Najib bin Aris against public prosecutor into consideration, which held that tendering certificate under section 90A is not mandatory, and even absence of the certificate, it may be tendered in oral way, the appellant have testified that the message were produced in course of ordinary use of the computer. As it is stated in the case of Bergamo Development Malaysia Sdn Bhd, the authenticity of the evidence had been proven by the appellant through the oral way. You may get the copy of the judgment from the court later.